Hey, good afternoon. This is Judge Torm. Sounds like we had some feedback on the line, and it's gone. Great. Before we go on the record, I just want to get a roll call of who's here on behalf of TCC and who's here on behalf of the applicant. And if there are any other parties present, we can go from there. First, let me ask, do we have our court reporter? Okay, that would be a problem if we don't have a court reporter.
No, I am here, Christy Shepard.
Oh, great. Thank you.
You're welcome.
Okay. Mr. Aramburu, are you on the line? It could be that he's muted. Andrea, if you're on the line, could you give the instructions for coming on and off mute? Or other FSEC staff if you're on?
Yes, this is Alex. I'll post it. Just one moment.
Yeah, and Alex, if you could just go through it verbally, that would help as well. All right, well, Alex is apparently posting that in the chat or whatever function on MS Teams to make that visible to everyone. Mr. Aramburu, have you figured out how to come on and off mute to let me know you're here?
This is Lisa Massengill. You might need to do *6 to unmute yourself if you are using a landline or a cell phone.
Thank you, Ms. Massengill. I appreciate you getting that out there verbally. Mr. Aramburu. Okay, apparently he's not with us yet. Maybe he's been delayed. Who do we have from the applicant?
Good afternoon, Your Honor. Can you hear me?
I can.
Yay! It's Willa Perlmutter from Stowe Reeves on behalf of Scout Clean Energy. With me is Ariel Stavitsky, my colleague, and Mr. Kobus is also on the line. And for what it's worth, Your Honor, I do see Mr. Aramburu is shown as an icon. I think he's here somewhere.
Okay, well, sometimes technology is not kind to us on any given day. I've been there. Maybe Mr. Aramburu's in that space right now, but I'm glad that he's on the line. I fully expected he would be. Other parties, is anyone happening to be listening in from Benton County?
Yes, thank you, Your Honor. This is Aziza Foster.
Remind me the spelling of your first name, Ms. Foster?
Sure, it's Aziza.
Okay, good. I had it right. Anybody else there with you from the county?
I don't anticipate anyone else.
Okay. How about, is Counsel for the Environment on the line?
Yes, Your Honor, Sarah Reineville's on the line.
All right, thanks, Ms. Reineville. And anyone on from the tribe, Yakima Nation?
Good afternoon, Jessica Houston for the tribe.
Hi, Ms. Houston, nice to talk to you. Anybody else there from Yakima Nation with you?
It will just be me representing the tribe today.
Okay, great. Mr. Aramburu, any luck getting connected so we can hear you?
Can you hear me now?
Now we can. For whatever reason,
Okay,
it's a bit
good.
of a
Here I
echo
am.
when we're
Yes,
both on.
Richard Aramburu for TCC present.
Okay, glad we could solve the technical difficulties. Awesome. All right, I think we're probably ready to go on the record. So if the court reporter wants to start now, that'd be fantastic. All right, good afternoon, everyone. This is Judge Torum. We're in the matter of the Horse Heaven Wind application. Today's date is July 3rd, 2023. It's now 3:20 in the afternoon on a nice Monday afternoon. And we have one issue in front of us today. There's a motion to compel the testimony of Scout Clean Energy's Dave Kobus that was filed on June 23rd by intervener Tri-Cities Cares. And Mr. Aramburu is on the line to represent for that purpose. Also on the line for the applicant who are opposing the motion to compel and the accompanying letter or the request for sanctions from TCC, we have Willa Perlmutter. We've established she's accompanied today by Ariel Stavitsky and Mr. Dave Kobus of Scout Clean Energy. We have other parties on the line that are not necessarily participating in the motion itself, but are listening in from Benton County. We have Attorney Aziza Foster on the line, Counsel for the Environment, Sarah Reineveld is on the line, and on behalf of the Yakima Nation, we have Jessica Houston, another attorney from their Office of Counsel. That's all the parties that we need, and for the public listening in today, as was indicated in the notice, there's not going to be an opportunity for public comment. This is strictly a procedural matter and a discovery issue that's come to my attention that needs to be resolved hopefully today. And whatever ruling I might come to, I'm hoping to reduce to a short written order that's likely to be published tomorrow. Well, tomorrow's a holiday of July 4th, so likely on the 5th. Mr. Aramburu, again, you filed your motion on June 23rd. I have the applicant's opposition that was filed on June 28th, I believe it was. And then you filed a reply shortly before this conference this afternoon. Can you summarize quickly for us so we're all on the same page exactly in a few words what it is the relief you're seeking?
Our motion, just a second. We're having some computer difficulties here, and pardon me, we're having some trouble hearing the other parties. So the summary of the motion, it's in front of all the parties, does not need a lot of additional work. We believe that Mr. Kobus's testimony is relevant to the proceedings here, that his deposition is appropriate to be taken, that due to the lengthy refusal to make Mr. Kobus available for the deposition, sanctions should be ordered. And because of the late filed motion for protective order, which should be denied, costs and expenses related to that should be awarded as well. And then in addition, we have the procedural aspects of the motion itself, of the proceeding itself. We've asked that Mr. Kobus be made available at a time convenient to TCC counsel, which is getting to be a problem because of the testimony requirements, and that we have some reasonable period of time to use his deposition for purposes of preparing testimony during the course of the hearings. So everybody's read this. I don't know if you want anything more.
No, that'll be fine, Mr. Aramburu. I just wanted to get us on the same page of the relief you're seeking, and then I'll ask the applicant to again state where they're willing to grant that relief without me standing in. I understand there was a question of scope of the deposition and then opposition to the sanctions. So Ms. Perlmutter, in the same level of detail as Mr. Aramburu just provided, if you can summarize the applicant's position and where I'm not needed and perhaps where I am on this.
Thanks so much, Your Honor. At the outset, I would like to note that I was not served with the reply brief that Mr. Aramburu apparently filed this morning. Ms. Stavitsky sent it on to me just about an hour ago, so I had no idea that there was anything that I needed to respond to other than what was in the motion. That said, I do want to just flag very briefly a couple of things. First of all, we are not, and we have never refused to make Mr. Kobus available. We would like to put some limits on the scope of his deposition, consistent with what the court has always said, which is that the role of TCC is limited to some issues, to some specific issues. And I understand that those issues are to be broadly construed, but at this point, the only thing that we've gotten from TCC has been, we're going to ask him about everything, everywhere, all at once. We would also note a couple of other things. One is that the court had said that this is with regard to the request for TCC to have an additional 3 weeks after the signing of Mr. Kobus's deposition for them to then submit additional testimony. We'd suggest that that's not necessary. First of all, the court has already made it very clear that that pre-filed testimony is really to be the chief source of discovering each party's principal positions. And obviously, maybe not obviously, but Scout Clean Energy is of course filing pre-filed testimony like everybody else. To the extent that that TCC asks for an additional 3 weeks after Mr. Kobus signs, I just wanted to point out that in Exhibit B to my opposition, to our opposition to the opening motion, Mr. Rambaru specifically said that he did intend to file a motion to compel. That was on June 2nd. And I think the court might be mistaken, or maybe there's another discrepancy. We received the motion to compel on June 25th. In other words, more than 3 weeks after the first time that Mr. Rambaru said that he intended to file a motion to compel. And also that was the very same day that the court admonished the parties to file any motions for discovery promptly. We'd suggest that the delay here is really TCC's, to the extent that they're looking for additional time in which to submit testimony. I'd also point out that in the court's letter from June 30th, which I guess was the end of last week, the court specifically indicated that, or reminded the parties that the second pre-hearing conference order doesn't set a deadline or cutoff, that the parties could continue to take discovery from each other after the deadline for the pre-filed testimony. And indeed, the court opened the door, or left open the door, for the possibility that, quote, if significant new information is discovered, the parties can supplement their pre-filed testimony. So to the extent that TCC is looking for a 3-week sort of reopening of a window, that just doesn't, not only is inappropriate, but it also doesn't make sense. I'd also point out that with regard to the motion for sanctions, Your Honor, I hope it's clear from the materials that we provided to you that we really have been trying hard to get the parties to a place of agreement or sort of mutual respect to move forward with this deposition. And we've been shut down at every opportunity. In fact, I feel frankly a little foolish about having suggested alternate ways that we could get at what it is the TCC is looking for. In other areas of my practice, certainly informal discovery is routine. This offer to answer questions submitted in writing, candidly, I mean, I thought was possibly a way to break the logjam. To the extent that there's any request for sanctions, those are so, I don't want to say draconian, but those are so harsh and should be limited to special cases, just not every case where somebody disagrees with the position being taken by a different party. And then I guess the last thing that I would say, this is, I think it's a little bit problematic, is with regard to our request for a protective order. I do think that TCC is incorrect in saying that we should have filed it sooner. I think we could have filed it sooner, but it's not in as much as there was, after the initial request for deposition, while the parties I thought were still talking, there was no pending deposition notice. Therefore, there was no reason to file a motion for protective order. As I noted in our opposition, certainly the rules contemplate an either or approach, but in what I've seen in the reply that we got just a few minutes ago, TCC is citing to CR 30H, but 30H3 specifically carves out an exception for the kind of protective order that we're seeking, where there are limits put on the extent of questioning at a deposition. And I think, frankly, TCC may not have been entirely forthcoming, or perhaps they were mistaken. But there is an opportunity within CR 30H3 that specifically carves out an exception for 30D, and 30D then gives a judge an opportunity to set guardrail, the kind of guardrails that we're limiting. Candidly, I have to be upfront with you, which is that 30D does seem to imply that those motions have to be made during the course of a deposition. I would suggest that for judicial economy, that's something certainly the court could look at here. I guess the last thing is that certainly, we do not concede the amounts that are being asked for by DCC. I know that's one of the things that they represented in the reply to our opposition. We are not by any stretch of the imagination agreeing that those would be appropriate numbers for sanctions. Thanks so much.
All right, thank you, Ms. Perlmutter. A little bit more detail than I anticipated, but I appreciate you laying out thoroughly the applicant's position. Mr. Aramburu, I'm sure that you're wanting to respond to many of the details there, but again, your motion and the declarations and exhibits speak for themselves, but I do want to give you a chance, briefer than Ms. Perlmutter was, if you have anything you want to say in reply.
Well, I want to first of all say that I did not understand this to be oral argument on the motion. We didn't ask for oral argument, and none was appropriate. Your Honor, I've been doing this for a long time. People take depositions. They understand the scope of the case, which you have set forth issues for us to be broadly construed. The idea that a party, that counsel representing a deponent is entitled to some sort of list of questions or to dictate to the party seeking the deposition how that deposition should be taken, whether there should be written questions or not, is entirely contrary to the entire scope of our recent discovery rules, which were adopted more than 50 years ago. So we've seen nothing but delay from the applicant here. The deposition of Mr. Kobus, who's Mr. Know-it-all by his own reference and characterization, is entirely appropriate to address questions that are tied to the issues that we have here. There's no reason for any more detail than that. And as Your Honor knows, during the course of depositions, there are objections made. I don't think there's going to be that many objections here, but objections are made. And sometimes they have to be ruled on by the court, or by, in this case, the presiding administrative law judge. So that's the ordinary course of depositions. And there is no procedure that I've ever heard of that allows a party during the course of a deposition, and this is what was requested in the protective order, to tell a witness not to answer a question because that lawyer thinks that it's somehow not within the scope of questions to be asked. That is, there's no authority cited in the response for that, what is largely an outrageous proposition. And that part of the protective order shouldn't, certainly should not be considered or granted. We intend to be respectful to Mr. Kobus. We intend to keep within the parameters of pre-hearing order number 2. We've seen no grounds by which any protective order should be granted. It talks about operations, expense, embarrassment. There's none of that that's involved here, nor would we intend to have any questions in that regard. So we think the order should be granted. There should be a reasonable time to use the fruits of the deposition to prepare testimony. And we think that sanctions and expenses, given this long drawn out process, should be granted. And I hope I didn't go on too long, Your Honor. That concludes what I have to say.
Stay with me for a moment, Mr. Aramburu, before you hit the mute button. The one piece that I don't think I saw in anybody's motion was a reference to CR 26I and the required counsel conference before a court would entertain sanctions. Did you characterize any of the discussions you've had with Stoll-Reeves and the applicant's counsel to have been a 26I conference, Mr. Aramburu?
Oh, yes. I mean, we had all of our backs and forths about this issue have been recorded by both sides. We had extensive back and forth regarding this. We're fully beyond what is required under Civil Rule 37 to consult. We have done that. That is expressed by the record that we have here. So that has been fully met, and we have been, in my view, cautious and in terms of going about this and making sure that we expressed our concern. So we fully met that requirement, John.
Okay, I just hadn't seen an explicit reference to 26I in the reading I had done to this point. And in my practice, typically that's one of the first things that I've seen, at least in the civil practice that I see as an administrative law judge when someone is seeking sanctions. But it was strongly implied, and I wanted to make sure we were on the same page for that and get it out there. Ms. Perlmutter, I want to give you a chance to respond and tell me if you don't think the requirements for CR 26I have somehow not been met by the back and forth that both sides have documented.
Your Honor, I want to keep this short, of course. Yeah, we absolutely, this is not a knee-jerk reaction. This is a substantive reaction. We absolutely do disagree with any allegation that there's been a meet and confer under 26I. That is what I was trying to accomplish with my communications with Mr. Arambaru. And as I said, all we got, as we said in the reply, in the opposition, all we received was no, no, no. We would say that there was no good faith attempt whatsoever to try and get this hashed out, at least on the part of TCC.
Okay, well, that's what we're going to do today. At the very least, we're going to get a deposition scheduled, and I'm going to hear from TCC a little bit more and give some guidance as to what's going to happen at that conference. I'm going to make sure I'm available. Mr. Kobus is available, and both sides are available to do something sooner rather than later, so it's meaningful for the remaining round of testimony that TCC might be filing, and consider any extensions needed to allow the record to be created. Ms. Perlmutter, would you also clarify for me, Mr. Kobus is not a witness with pre-filed testimony in the first round filed by the applicant, is that correct?
That's correct.
And do you anticipate having him file testimony as due on, I think your last round would be July 12th, is that correct? Is he going to be filing any testimony?
Your Honor, I don't believe he is. I defer to Ms. Stavitsky on that, but I do not believe we intend to pre-file testimony for him. Can I ask Ms. Stavitsky to weigh in, please?
Yes, please.
Yeah, certainly, Your Honor. At this time, we don't expect to, in part, for the reasons Will explained, we don't believe there are additional. We believe that all the relevant subject matter should be covered under our other witnesses.
Okay. And Mr. Arambaru, I know that pre-filed testimony doesn't give you an opportunity necessarily to call someone as an adverse witness. Was there anything that TCC planned on doing as far as calling Mr. Kobus as a witness? I would imagine it would be difficult to get pre-filed testimony from him, especially if you haven't yet been able to meet with him for the deposition. What's the intent here?
Judge, this situation is very unusual because the applicant has filed a lengthy application for site certification and has amended that site certification, but there are no witnesses that have been identified to speak to the contents of that site certification application. And in ordinary course, the applicant brings forth witnesses to describe the materials that they have submitted and stand for cross-examination with respect to that application. That hasn't been done here, and I think it's a major defect in the proceedings here, because they're essentially they're trying to keep anyone from asking questions about the site certification application. So no, there hasn't been any effort. I think that the proceedings to this point have been defective. I was expecting to see some witness that said, I participated in this, and here are the witnesses and experts or whoever they are that were responsible for these sections of the application. That has not happened. I think that's a major defect. So, but in more of a short answer to your question, yes, I intend to ask this witness, who identifies himself as Mr. Know-it-all, with regard to questions with regard to contents of elements of the application for site certification.
Okay, that helps
Your
clarify.
Honor,
again,
if I may.
scope.
Oh.
Is this Ms. Stavitsky?
Yes, Your Honor.
Go ahead.
Just to clarify one point, I'm not sure exactly what is unusual about the process, and I'm speaking with respect to applicants' approach to the pre-filed testimony. That's actually exactly what we've aimed to do in our pre-filed testimony, is provide various witnesses that each covered their respective sections of the application, and which witness goes with which section is actually explicitly outlined in the testimony that we've submitted. So just to provide that context, that's exactly the approach that we've gone through with our submissions thus far.
I understand that, Ms. Stavitsky. I think what I'm hearing from Mr. Aramburu is that Scout Clean Energy came to the council with Mr. Kobus as the main proponent and spokesperson for this application back in February of 2021. He presented all of the material at the informational meeting as well as at the council meeting in which this application was filed, and did come off as the spokesperson for Scout up until we got into further stages of things. And now the litigation and the adjudication, he may or may not be part of the applicant's case in chief. As I understand Mr. Aramburu's position, the chief spokesperson and the person with the most knowledge of the application when this whole thing started 2+ years ago. So I understand the desire to speak with Mr. Kobus and learn whatever Mr. Aramburu thinks is going to be the differences between what's already been pre-filed testimony and what might be in the application that's not yet addressed in TCC's mind. I do think it's appropriate to make him available for the deposition, particularly because he's not filing any testimony in this matter. And that's a choice for the applicant. I think in past practice, sometimes the proponent of the project that signed the application and presented it to the council has testified. I don't know that that's a rule or a requirement, certainly not a requirement, but it may not have happened in every application, but it has in the past, at least on occasion. Now, Mr. Aramburu will, as you're willing to produce Mr. Kobus, get access to him and be able to ask him a reasonable range of questions as described today. Discovery is intended to lead to relevant information. It may not be admitted or brought forth at hearing, but it can be used to help round out TCC's case in opposition to this application. I think today the best thing to do is to figure out when this can be made to happen. My understanding is the original deposition notice was sent out for early last month, and Mr. Kobus was not available and did not answer the notice of deposition. And here we are a month later, still trying to get that scheduled. Given the amount of other things that have happened between now and the original deposition notice, I'm surprised still this hasn't happened, but I guess it's understandable at some level given the other business. And I hate to do this on a record, but let's get our calendars out and find a time that works sooner rather than later. I'll ask Ms. Perlmutter, and maybe you'll have Mr. Kobus speak for himself. What are the limitations on availability coming up, and whether we have a national holiday tomorrow to observe? There's testimony due from the other parties on Wednesday, and then we have a few days, another 10 days perhaps, for the responding parties, TCC and everybody else that's on the line, to file their reply, but the applicant's going to be getting ready to produce testimony on Wednesday of next week. I get it, it's busy. When would Mr. Kobus be available? And first, actually, let me ask Mr. Aramburu, are you wanting him available in the days ahead, or are you wanting to focus on testimony first and then try to take care of this before we get to hearing August 9th and 10th, or 10th and 11th? Mr. Aramburu, what's the desired timeline other than June 5th was it, and now every day that goes by is another difficulty for you?
Thank you, Your Honor. The every day that goes by, yes, indeed, is a further difficulty for us. in terms of preparing. And one of the difficulties we have at this stage of things is that, as I indicated in my previous communications, we want to use Mr. Kobus's deposition testimony to assist other witnesses in testimony that they may have. Given the schedule that we have at this point, that's going to be very difficult. It is simply impossible for us to try to schedule, because of the needs of pulling together testimony due on July 14, to do it before then. We need a reasonable amount of preparation time. So I would suggest that the first date for testimony for Mr. Kobus's deposition should be July 20. I don't want to wait too long, but we just can't do it next week, Your Honor. It's just impossible with the schedule that you've set. So we think July 20 would be a reasonable date. That'll give us time to get our testimony in and then focus on the deposition.
All right, Mr. Ramber, I appreciate that. Can I give you some polite pushback as to maybe we could carve out a few hours earlier so that you'd get this information in a more meaningful time frame? My only polite question here really is, you filed a notice of deposition for June 5th, which would have implied to me you were ready to go with whatever questions on that date. I'm willing to push it out to that after testimony's done, if that's what the relief you're seeking, but I just was assuming that you were ready to go when you noted the deposition for a month ago.
Yes, we were ready to go with some general questions. We didn't finish those because we've been put off ever since then by the delays from the applicant. So I am out of the office a couple of days next week. I think we could possibly look to the 18th of July, but no sooner than then, Your Honor. I mean, we tried to set up a reasonable schedule for use of the testimony and doing all of these things. And now we're backed up against a very severe limitation for testimony to be in by the 14th. And that's a major job. I have to be out of the office for a couple of days then. And so I think really the July 20 is a reasonable date. We could do it July 18, I believe July 19 is the FSIC council meeting. So I would say I really think the 20th is a good date that allows us to recover from the process of presenting all of this testimony and get ready for Mr. Kobus's deposition. So we'd request that as the date.
Okay, I understand the evolution of how things have gone and people's schedules being what they are, including yours. So I wanted to hear the answer to that, Mr. Ramber, and then give it the full consideration and respect. I'm available a lot of the time on the 18th if I was needed. The 19th could be made to work for my availability if needed to respond to anything during the deposition. The 20th is a little bit more limited, but still a possibility given certain time windows. Let me hear from Ms. Perlmutter as to the scheduling if Mr. Kobus is available on any of those 3 days from the 18th to the 20th of July, or if not, why not?
I'll need to check. We can ask Mr. Kobus directly. I would note two things, Your Honor. One is that I'm actually going to be on a flight on the 19th, and that's going to pretty much mess up my whole day. And then on the 20th, I'm available, but it looks like we already have a deposition scheduled for that day in this matter. The deposition of Jason Fedora is scheduled for the 20th.
And what's the timing for that one?
Let me just take a look. The notice says that it's going to be at 9 a.m. on the 20th.
Okay. And Mr. Arambaru, I take it that's your deposition notice, or is that from another party?
That's a deposition notice from the Yakima tribe.
Okay. Let me then ask if
we may be attending that as well, but that's the notice from them. I'm sorry I didn't consult the deposition schedule from the tribe.
Okay, well, I obviously don't get copies of the notices of deposition, nor should I. But let me ask Ms. Houston if you anticipated how long the deposition of this person would be on July 20th at 9 a.m.
Good afternoon, Your Honor. I think we actually noted it for all day, but based on our deposition of another WDFW employee, which only went about half a day, I anticipate that it might be along those lines in terms of timing, but I can't say for sure.
Okay. As I'm wondering if we tried to get in Mr. Kobus that afternoon, if that would work, but I'm going to turn back to the July 18th date as well, given the deposition timing for that witness. Mr. Kobus, you're on the line. You're hearing all of this. We're talking about your schedule. Can you enlighten us to your availability July 18th, 19th, and 20th?
Yes, Judge Torm, are you able to hear me?
I can.
Okay. I will make myself available on either of those days.
Okay, so all three of those days could be made to work for you.
That's correct.
All right, thank you. Mr. Aramburu, given the discussion we've had and Ms. Perlmutter's travel arrangements on the 19th, would you prefer to schedule this for the afternoon of the 20th, since it's not your deposition in the morning with the Fish and Wildlife employee, or would you rather be on the 18th, where, as far as I know, there are no other competing depositions?
Well, Your Honor, I do want a little opportunity to recover from our filings the prior week. So can we do it on the 21st? How is that for everyone? That's open on my schedule.
That works for me, Your Honor.
I can accommodate being available probably from noon onward on the 21st on Friday. Mr. Kobus, would that afternoon work for you?
That would be acceptable to me as well, Judge Torm.
Okay, well, it sounds like we've got a date on July 21st. And if you set that for, actually I could do, from 12 p.m. onward. Mr. Aramburu, what would your preference to begin your deposition, and how long of timing are you asking Mr. Kobus to be available on that Friday afternoon?
When one speaks of the length of depositions, we don't know the length of the answers. Here's what I'd like to do. I know you want to be available to resolve any issues that may come up. I would suggest that we start the deposition at 11 o'clock. You would be available at noon, and then we schedule for possibly 3 or 4 hours. I don't know at this point, but I think Mr. Kobus should be available at least until 5. All
right. Ms. Perlmutter, is that available and acceptable to the applicant?
Yes, it is, Your Honor.
Okay,
Yep.
Great. And Mr. Kobus, if you'll carve out that afternoon from 11 a.m. till 5 p.m., hopefully it won't take quite that long for your deposition. Is that something you're going to be able to do?
I will do that. Thank you, Judge Torm.
All right. So I'm going to ask Mr. Aramburu to set up a notice of deposition, and for this particular one, to file a copy with FSEC so that I get a copy and have it on my calendar. And I'll make myself available for telephone standby. Off the record, I'll make sure, Mr. Aramburu, I'll send you a separate email and copy Ms. Perlmutter and perhaps the other attorneys with my cell phone number, and make myself available during that time frame. Well, I'm hoping the phone doesn't ring on that Friday. We'll see what happens. As for the scope of the deposition, Mr. Aramburu, let's talk a little bit about that. I can put it in the written order, but I think today would be helpful to give some guidance verbally. You were going to enter something there, sir.
If you're going to be involved in the course of the deposition, this will probably be via Zoom or some other format. So it would probably be appropriate to figure out a way that you could be involved in the Zoom hearing or otherwise be as a part of the recorded testimony.
And I can certainly be called by telephone, or I can use my cell phone application of Zoom if need be. So whatever arrangement you think is acceptable, if you want to do an off-the-record, check of that technology at some agreeable time beforehand, I'm willing to do that as well to make sure things work. So you let me know, Mr. Aramburu. Obviously, I'm not going to show up wherever it is in person, but I can be available by Zoom or by phone.
My intention originally and my intention now is to do this via Zoom.
Okay, then I'll make sure the cell phone is charged and the Zoom app will be available. If a link is sent to me after a phone call to find me, we'll make sure that happens.
Let me ask the parties. As I understand, Mr. Kobus is a resident of the Tri-Cities area. So there's a possibility we might do the deposition live at an appropriate location in Tri-Cities. Does anyone have an objection to that as an alternative?
Yes, I do, actually. I know this is very weird to object and demand a Zoom deposition, but I'll actually be in Salt Lake City that day.
Well, I noticed that the applicant has 4 lawyers that are continuously involved. I would like the option of taking the deposition in person, which is the standard course.
Understood, and we'd appreciate your consideration on this. I'll be the one handling Mr. Kobus's deposition.
Okay, I'd be happy to talk to you about that offline.
Ms. Perlmutter, this is Judge Torum. I would hope if Mr. Kobus is available that day in the Tri-Cities, and if there was a way to get an associate to be present, that could be made to work. It might facilitate the handing of documents better than Zoom might be, at least on his end. And we could sort out, if you can find a way to do that, fantastic. If there is going to be it all by Zoom, I think it might take longer, frankly, for these things to happen. I think as the parties know, my personal preference is to do these things in person. And we have some other limitations on the adjudication in that regard already. If the deposition could be done face-to-face, that might even make it easier on Mr. Kobus and less stressful, particularly if an associate could be there with him. I'm not directing that. I'm suggesting it might just smooth things along here.
We can make it work, Your Honor. I will note that I think we all, I don't want to just say me, we've all gotten accustomed to Zoom depositions, but certainly we can make somebody available there, most likely me. I'll make other arrangements for travel.
Again, I don't know what your trip to Salt Lake City is about, and I don't need to. If it's important, do it. If it's something that can be compromised and you prefer to be the one, Ms. Perlmutter, then so be it. Again, I'm making a suggestion, not an order on that regard. So
we'll figure it out, Your Honor. It's a business conference, but we'll figure it out.
All right, I hope you will. And I appreciate the tenor today, because the tenor in writing has not been something that I think bodes well for how litigation could go in this. I appreciate the friendly, candid responses today, and I hope that we're at least diffusing some of the tension that comes right out of the pages that were filed, even electronically, is leaking out on my screen. And I'd hope that every party would take some of that shrillness out and just focus on what the mission is here, to get the relevant information in front of the requesting party and make it happen. Let's turn to the scope of that relevant information now. It sounds as though, Mr. Aramburu, that you're seeking background on how the application was prepared. It sounds as though you're seeking information on how the application came to be amended. That seems like a pretty general ballpark of what you're asking for. Am I correct?
Yes, we haven't formulated our individual questions. We've been busy with testimony and other things, but yes, we will have questions about the original and amended application. And yes, we will ask those questions.
And given the application preparation role that Mr. Kobus had, at least as my understanding, Ms. Perlmutter, is there some particular area that you're seeking to not have inquired into by TCC?
Your Honor, first of all, this is the most we've ever had articulated as the basis for the questions that TCC intends to ask. In my limited experience in FSEC proceedings, it sounds to me as though the issues around the preparation and amendment of the application go outside the scope of what the court has already identified as TCC's role. And so it was our hope and our request that the scope of the deposition be limited to the things that were specifically identified for this intervener. So that would be, the extent of the impact on wildlife, on the landscape, and together with Benton County, the land use issues.
I'm not sure I'm willing to limit it to only those issues because TCC clearly is working in alignment with some other parties, and they may have witnesses as to how the application was developed. There's a number of issues that everybody knows I've limited from the adjudication, and I hope that not a lot of time would be spent on those. But it may be that Mr. Kobus's role in preparing the whole scope of the application provides the needed background and foundation for him to be able to answer the further questions that Mr. Arambaru will craft, specifically regarding those areas that Mr. Arambaru's client is got a stated and significant interest in this application that will come out during the adjudication. I appreciate that the applicant is looking to the orders on the scope of intervention of this particular party. And I'm not saying that's wrong. I'm saying I'm not going to pre-limit the questions to those areas because there will be some background and other things that Mr. Kobus brings that are not directly potentially related to only TCC's interests that I've narrowed in the adjudication orders. I want to give Mr. Arambaru the appropriate latitude to find out what Mr. Kobus knows about the areas that TCC is interested in. Some of those may not be admissible evidence in the adjudication based on the scoping and the orders that I've issued, but they may be relevant information that allow his witnesses to comment on the areas that are relevant to them. I hope that makes sense. It's a little bit, as I say it out loud and listen to myself, a bit of a roundabout and almost circular logic, but I do want this deposition to not have a whole bunch of phone calls to me saying the applicant thinks this is outside of what TCC is going to be presenting in August of this year. But if they're looking for information that might influence that, I want Mr. Kobus to answer it under oath, even though that he's not going to be a witness and he won't be held against him. It might be something that TCC cites to his knowledge and somebody else's opinion during the adjudication. It very well may happen that way, Ms. Perlmutter, and we could spend a lot more time arguing about that than actually just having the deposition. And that's my goal of today, to get it scheduled, get the information out there for all parties, and then we can sort it out later, a lot more later, as to what's admissible at hearing. That to me is where we should spend our time, what's going to come before the council at the adjudication, not essentially the recipe of how all that information is created. That's where I'm coming from, and I think the deposition would be a lot shorter if we're not arguing about specific questions. I'm not sure the harm that could come from Mr. Kobus answering a few questions in background about areas that are not specifically designated for TCC to litigate. Ms. Perlmutter, any questions kind of on the ALJ's view on that?
We understand your position, Your Honor, and certainly we'll do our very best to honor it as we move forward.
And Mr. Arambaru, am I speaking out of turn here on how I'm directing your scope of the deposition, at least verbally here?
No. We intend to be courteous. We intend to stick to the issues that we have here. We're not interested in some extensive long deposition ourselves. So I think this is going to go just fine, Your Honor. if it doesn't for whatever reason, I'm pleased that you'll be available to help the parties sort through any disagreements about questions.
All right. And Mr. Rambraj, for the record, you've never been anything less than courteous in all the interactions we've had and pre-hearing conferences or otherwise during the course of this adjudication. So I have no other expectation than that's how it will go when this deposition goes forward on Friday, the 21st of July, starting at 11 a.m. And I'm counting on that my phone's not going to start ringing off the hook at 12 noon. I want to take the rest of the motion and response under consideration and issue something in writing over the next couple of days. If you don't see it on Wednesday, it just means I'm still thinking about it and that my outdoor hiking tomorrow on July 4th has meant I didn't do any work on the holiday. So I'm going to try to get to this in the next few days. Certainly by the end of the week, you'll have my ruling on any other specifics regarding sanctions or other things that are raised in the motions. So we've got a date, we've got a time, we've had a general discussion of scope and expectations from the ALJ. Mr. Aramburu, anything else that TCC needs today?
No, and given our schedule here, Your Honor, a few extra days to work through the ruling on the motion certainly is just fine with us. So no, we'll be prepared for our deposition, Mr. Kobus, 11 a.m. On July 21.
What I would invite is if you have anything you think you can get out of the way with interrogatories or requests for admission, and maybe that's asking already too much because of what's going on between now and then, that might help set up on an expedited reply from Mr. Kobus, shorten up the deposition. But again, you may not have time to do that, and the applicant and Mr. Kobus may not have time to respond. Just to, again, not the litigant, but the judge on the other side of the bench's view of, oh, wouldn't that be easy? So it's a different thing where I'm sitting than when you are. Mr. Ramber, with that, anything else today?
No, thank you. Thank you for setting up the conference today, Your Honor.
All right, let me ask Ms. Perlmutter if she has any questions or anything else, guidance that she needs before I issue the written order on everything else later this week.
No, Your Honor.
All right, I hope it was an hour well spent and we've moved the ball forward on this. Do any of the other parties, Benton County, have anything they have a question, Ms. Foster?
No, we don't have any questions, Your Honor. We've just, I guess, let Ms. Perlmutter know that Benton County would likely have questions for Mr. Kobus as well during the deposition.
All right, and you've heard what the scope recommendations are from me. So I hope if you're going to participate that it's all within that and you'll coordinate with Mr. Aramburu as the lead counsel that's been asking for this. Ms.
Yes,
Reineveld, any questions? Thank you, Ms. Foster. Anything else, Ms. Reineveld, any questions?
Sorry, nothing from me, Judge. Thank you.
All right, thank you. And Ms. Houston, any questions, concerns from the tribe?
No questions or concerns from Yakama Nation, but I would also like to note that it's possible we might have questions for Mr. Kobus as well.
Understood. So if you're participating in the deposition, please coordinate with Mr. Aramburu so there's not any duplication. And I don't know if it's practice for all of you to serve a joint notice of deposition or separate notices, but formalize that so the applicant knows those questions might be coming. And Ms. Perlmutter, given those indications from the county and from the Yakama Nation, any other questions the applicant may have?
No, we don't, Your Honor. Thank you.
All right. I hope it doesn't add too much complexity to have multiple parties, but if they coordinate, hopefully things are done at a reasonable time on Friday, the 21st. Thank you all. Mr. Kobus, thank you for arranging your schedule and being forthcoming today. With that, it's 4:10 p.m. This conference is adjourned. Thanks all. Have a good afternoon. Enjoy the holiday tomorrow.